which happens for the purposes of understanding what the numbers are. But an undue election of a member of a constituency is a concept which the court must apply all of its expertise to determine the very question which the Constitution, or the very obligation which the Constitution laid upon it, namely, whether any person has been validly elected. That's the question. An undue election is about a person who has not been validly elected. And when will that happen? Well, Section 116 tells us the person complaining can complain about by reason of, number one, want of qualification. Number two, reason of disqualification. And here are the ones that we're really interested in, because my clients don't raise anything about qualification or disqualification. But, firstly, a corrupt practice. I should say it's third on my list. Fourth, an illegal practice. Fifth, an irregularity. And sixth, a capacious phrase capable of taking upon anything that may be relevant for the court to exercise its power properly to determine whether or not there was a valid election. The phrase is, or by reason of any other cause whatsoever. So those are the grounds that can be presented. And once presented, before I get to once presented, and who are they presented about? This really puts to bed the complaint about the IEC, because the IEC doesn't even have to be joined in these proceedings. The complaint, we told in Section 116, must afford every other person that was a candidate to join, and it must be directed at the member whose election or qualification is complained of, hereinafter referred to as the respondent, who was a candidate election. So the respondent in this election petition is the candidate who you're challenging. Now, it may be useful to invite others to the table, to the trial. It may be a salutary practice to serve upon the IEC, but it's certainly not a requirement. It's not a non-suitor in these particular proceedings. Such a person who's then delivered the petition is then entitled to what the rest of the chapter contemplates, namely a trial. They're entitled to, Section 116 tells us, I beg your pardon, Section 121 tells us, they're entitled to have their election petition tried. An election petition, says the section, shall be tried and determined by the High Court within 90 days. They entitled under Section 125, on the trial of an election petition, a verbatim report is to be kept. In 126, witnesses will be summoned and sworn. What is contemplated here is a viva voce process. It's a hearing, a trial, not motion proceedings. So when we listen to some of these complaints about where the verifying, when it should be a confirmatory affidavit, are, with respect, they're completely misdirected. It's got nothing to do. We're not in a motion proceeding here. We're in a trial. 126, 2, again repeats. Any such witness who in the course of the trial of an election petition willfully makes a statement of fact. 127, on the trial of an election petition, the court may examine any witness. 128, no person who is called as a witness at the trial of any election petition may be excused from answering a question, etc., etc. What we're dealing with here is a trial. What is the point of that trial? It is to determine whether or not a person has been unduly elected. Yes, also unduly returned, but we don't have to worry about that. That's not what clients are interested in. Whether or not there's been an undue election. And that is the focus of Section 121. Because Section 121 sub 2 says, the following provisions shall apply with respect to the trial of the election petitions. It then says, every election petition shall be tried in open court. It will take place on any day prescribed by any rule or order of court. Notice must be given at least 14 days ahead of the time. It can be adjourned from time to time and from place to place. And then we get two different situations. E tells us that where we're dealing with an undue return, certain circumstances can happen. But here is what we rely upon, my lords and my lady. 121I. If the High Court determines that the respondent, that's the member who we're challenging, that the respondent was not duly elected. It's a different way of saying whether or not there was a undue election. If the High Court determines that the respondent was not duly elected and that no other person was or is entitled to be declared duly elected, the seat of the respondent shall be deemed to be vacant, and the High Court shall certify its determination to the President that a vacancy has occurred, the cause of such vacancy, and the constituency in which such vacancy has occurred. We come in our petitions and we tell you, these were the results. We're not in a fight because there's 15 votes ahead of one and we must recount that, we must see who should have, what the correct return is. We're not in that fight. We say we're in a fight, a much more fundamental fight. We say that the rules were so fundamentally broken in this fight that you can't accept the outcome of it. And no one, none of the 4 or 5 or 3 or 2 persons that were elected, can we say who should have been properly elected, because the process was so completely subverted that we can't trust its outcome. And that's what we urge and ask the court ultimately to determine. We don't know who should be elected, and we want you then to exercise the powers under 121I, determine that you can't say who should have been duly elected, and certify that fact to the President, and allow the President then, well, the next step will obviously be a by-election, a rerun of the election. Now, my Lord, may I ask you please to, and my Lady, might I ask you please to turn to page 21 of the bundle of papers in front of you, which is the petition of Mr. Boko, and where we see the very relief which we ask for mirrored in the prayers, the relief that we seek. And what we read in paragraph 63 there is the following: wherefore your petitioner prays for an order in the following terms: directing that the second respondent was not duly elected and that no other person was or is entitled to be declared duly elected. I want to emphasize that that simply is exactly what 121I contemplates. We are seeking relief under 121I, not under 105. I'll come to that in a moment. We then, in 63.2, directing that the declaration made by the returning officer for the said election to the effect that the second respondent was duly elected is null and void. That's a necessary ancillary order to there being a declaration out there by the returning officer that this person was duly elected. The court must necessarily set it aside and declare it to be null and void. Then we say, declaring that the Bonington North constituency seat is vacant. That's exactly what you're supposed to do under 121I. You are to certify... you are to certify its determination to the President that a vacancy has occurred. And then we see costs. Now, my lords and my lady, with great respect, I don't know how it could be clearer to communicate to a person who receives this election petition that we seek the relief under section 121. But what have those who wish to prevent a ventilation and proper determination of this question done in this matter? They have, I suppose, done what every person who wishes to distract is. They've tried to cause a feint. They've tried to distract your attention from what's really going on. And they say, look, if you read this petition, you find repeatedly the reference to the words corrupt or illegal practice. And if we look for those expressions in the Act, then the only place that we find it used and linked also to the outcome of the election is section 105. And therefore, let's try and force this round peg into a square hole. Not of our making, but of their making. This is a false reality which they're trying to create and urge upon you. But if you look at our case, you will see, with great respect, that this case is, as I've pointed out in the relief, a case about an undue election under section 121I. But in paragraph 7, at page 7 of the very pleadings that we're referring to, and it's repeated again and again in every petition, we say, in this petition, your petitioner complains of the undue election.
Yes, but based on what? because you want to be more general insofar as the end result would be.
Yes.
That's what a court will determine at the end of the day. Upon a trial, if we get there,
Yes.
that's another issue. You seem to want us to concentrate on a trial and leave all the preliminaries that will lead to a trial. And my understanding of the respondents' issue of Section 105, when they keep taking us to 105, is not that that's the only place where corrupt and illegal practices are found. They are saying you proceeded under 116 and picked from the various grounds that you have access to under 116, and picked corrupt and or illegal practices and focused your petitions on that. You did not deal with irregularities in terms of indicating in your petition that you are complaining of irregularities, what those irregularities are, particularizing them. But you have dealt with corrupt and or illegal practices and to a certain extent sought to particularize those. And that the moment you focus on corrupt and illegal practices, there are specific provisions under the Act that deal with that and what should happen when you rely on those. That's my understanding. And not that you should have come under 105 because you are dealing with corrupt and illegal practice. No, you can come under 106 and pick whatever you want to pick. In this case, they're saying you picked corrupt and illegal practices. And the moment you do that, then you bring yourselves under the ambit of Section 105.
Yes. My lady, your ladyship is giving a very benevolent reading to the respondent's point in limine. The point in limine does not recognize that there's any basis outside Section 105A upon which my client might get relief. The point in limine, they say, is a defeater. It's a sudden death point. It's a silver bullet. We can't recover from this Section 105A, is their point, because they want, and they say that the petition is nullified because we don't come within 105A. But I'm going to address you now on what it is that we say, because I want to address your question. Let's just read page 56. It says, the petition does not comply with Section 105A of the Electoral Act in that it does not allege that the payment or money or some other act or the illegal practice alleged in the petition was made or done with the knowledge and consent or approval of the member or his or her election agent. And then they say that we've got no case. They say that you've got no power to listen to this matter. They say that you can do nothing more. My lords and lady, that can't be a clearer statement that they want to pigeonhole us into a single cause of action, namely 105A.
Have you not pigeonholed yourself?
No, because I'll address that now.
That is, I'll keep on repeating what I said and my understanding of their case. They're not saying, if my understanding of that case is correct, they're not saying you could not have utilized the ground of irregularity or any other cause whatsoever, but that you did not. In your petitions, you have not in any way indicated that you are proceeding under any other ground under 116 except corrupt and illegal practices.
Yes. So I'll address that point
yes.
on two
and
levels.
Then that the moment you did that, then you brought yourselves under the ambit of 105, and that then you did not comply with 105.
Yes. So I'll address that at two levels. Firstly, what our petition says, and secondly, why their interpretation of 105 is completely incorrect and where it applies. So let's see what our petition says. It says that at page 8, paragraph 12. So I was still at page 7, paragraph 7, but we've read that already. We said it was undue elected in the said election and commission of corrupt and illegal practices by the BDP, Director of Intelligence and Security Services, with the connivance of certain employees of the first respondent, as shall be fully particularized hereunder, and prays for the relief sought. In paragraph 12, your petitioner complains that the second respondent has been unduly elected, and then sets out that the Botswana Democratic Party, whose full further particulars appear under, in certain officials, I beg your pardon, of that party, engaged in corrupt or illegal practices, and that the DIS unlawfully aided and abetted them, and the IEC unlawfully aided and abetted them, and that the roll was not certified. Now, if that's not an irregularity, I don't know what is. It's certainly also an illegality. And that the first respondent contravened or permitted the contravention of the provisions of Section 28 of the Act. That may give rise to both an illegality and an irregularity. The point to be made is that a corrupt act can also be an irregular one. And an illegal act can also be an irregular one. And a corrupt act can also be an illegal act. There is an overlap between them. But the more important point, the fundamentally more important point, and that illustrates why I said to you earlier that we're dealing with two different worlds. Their case is that unless you bring that home to the member who's been elected, we can't complain. We can't get the court to consider it. Which is, with respect, the world of departure that is between us. We say that if a member who's elected is as virtuous as they come in their election, but the surrounding circumstances committed by whoever is such that it would lead to a conclusion that there's been an invalid election or an unduly elected person, then the court must intervene and stop it. Let me give you a completely neutral example. Let us assume, you'll forgive me because I don't know Botswana well enough in Gaborone, but let's assume that we have a constituency that is divided by a river. And the polling station is north of the river, but the majority of the people are south of the river. On the day set aside for the poll, there is a flood. Nobody from the south can get to the north. Nobody can vote as they do. By lucky happenstance, those people on the north side of the river do get to vote. And there is a predominantly BDP, there's a predominance of BDP persons. Such a person would step forward and say, look, I've been elected. I won the election. They would not allow for that constituency, a voter in that constituency or another candidate saying, but this is not a fair election. This person was unduly elected because we couldn't get there to vote. And they would not permit this court to examine that question. They would say, no. Before you're going to even look at question of setting aside, you've got to look at whether or not you have linked a corrupt or illegal practice to the member, the contesting candidate. I'm going to come to why that's even an incorrect reading of 105, but that's the world that they occupy. And we say that's wrong. It's not what the Constitution places upon you or what the Act demands. So let me deal with 105 now, if I may, please, my lady, and then perhaps it will also address the concerns that you're raising. They say, and let's read what they say from their heads of argument. So if you look at their written submissions, at page 4 of 26, paragraph 15, you will see at the top of that page they quote section 105A.
At 4?
Page 4 of 26.
Of the bundle.
Well, it's their written submissions. I don't think that's been incorporated into the bundle. It's BDP respondents' written submissions.
But you refer to page 4 or something?
Page 4, it's in the bottom right-hand side.
Oh,
page 4 of 26. 26 pages. They quote 105A there, at the top in paragraph 10. They say in paragraph 11 that corrupt practices are defined by section 90. They give you the definition of candidate. They tell you what a collection agent, they tell you what a polling agent is, and then they say this proposition. It is therefore clear that in order for an election to be voided by the High Court, on the basis of a corrupt and illegal practice, there must be a finding that the corrupt or illegal practice was committed by the candidate or with the knowledge and consent or approval of any of his election or polling agents. That's what they say section 105 means. Let's read section 105. It says, subject to the provisions of 102, 106, and 107, we'll come to those in a moment, if upon the trial, again a trial, if upon the trial of an election petition, the High Court certifies to the President that any corrupt practice or illegal practice has been committed in reference to the election, the subject of the petition, by or with the knowledge and consent or approval of any of his election or polling agents, the election of that candidate shall be void, and a fresh election shall thereupon be held. This doesn't speak to the knowledge of the candidate. This speaks to the knowledge of the polling agents and the electoral agents. It says, by or with the knowledge and consent or approval of any of his election or polling agents, the election of that candidate. It's got nothing to do with the knowledge of the particular candidate. What this is a red card. It says, if your election or polling agent knows what's going on, illegal and corrupt practices, doesn't matter that you don't know. You out as well, Mr. Candidate. You are gone, says Section 105A. It is a justifiable, rational, and entirely appropriate sanction that is imposed. It doesn't even speak to the knowledge of the candidate.
But it has to be read with 1023.
Yes, so let's read 1023.
That's how I understood that their argument.
You will recall that
Reading it holistically, at least insofar as illegal practices are concerned, because you raised that point as well.
Yes, so let's read what 1023 says. So 1023 says, a candidate shall not be liable, nor shall his election be voided, for any illegal practice under this section, that's section 102, committed by any person other than himself or his election agents.
Yeah.
So, if a third party is guilty of what is prohibited in 102, which says any person who votes or induces or procures any person to vote in an election knowing that he or that person is prohibited by law from voting at the election shall be guilty of an illegal practice. This is the illegal practice versus the corrupt practice type of situation. Any person who before or during an election publishes a false statement of the illness, death, or withdrawal of a candidate at that election for the purpose of promoting or procuring the election of another candidate, knowing that statement to be false or not believing it to be true, shall be guilty of an illegal practice. So these two kinds of practices, the one is where you induce or procure any person to vote in an election knowing that that person is prohibited by law from voting. So you go to a prisoner who's not allowed to vote and you say, I'm going to make it possible for you to vote. I procure your election. Then that's an illegal practice. 1022, if you publish a false statement about the illness or death of somebody, because what that means, if that person is a candidate, is that the structure of the election candidacy has to be done again. It presents a problem for the smooth flow of the election. If those two things happen, they're specific kinds of things that happen, then that is a two species of illegal practice. And if those two happen, then if they happen because of a third party, by any person other than himself or his election agent, then the election will not be void. But these are only two illegal practices. There might be any number of illegal practices, and there might be any number of corrupt practices. It doesn't follow that because these two that have been selected out as not voiding the election of the candidate, that any other illegal practice or corrupt practice won't have that consequence.
Are you saying, Council, that where an Act of Parliament specifies, tells us what illegal practice is,
yes,
or what a corrupt practice is,
yes,
we can then go outside and bring other things into the interpretation of what a corrupt or illegal practice is? Because you are saying these are the only two. There may be others.
Yes.
Yeah.
Yes. So let me Section 100, for example, gives you a different illegal practice. That's where you, for the purpose of promoting or procuring the election of a candidate in the election, engage or employ any other person for payment or promise for payment for any purpose.
Sorry, Section
100, sub 1.
Yeah.
That's an illegal practice. It's not one that is met by the exemption of 1023, because 1023 only applies, only gives you an exemption.
101.
100, sub 1. Sorry, sub 2, I beg your pardon. I think they're linked though. Any person who engages or employs another person in contravention, subsection 1, yes, they are linked, shall be guilty of an illegal practice.
Yes.
So there are species of illegal practices which are provided for in sections, I just want to be sure about this, sections 99, 100, 101, and 102.
I don't have any problem with those that have been indicated or referred to in the Act. What I was asking from what you were submitting is that there may be others not specifically mentioned. That's what I thought you were saying.
I apologize if I communicated inaccurately. It's enough for my submission, with respect, my lady, for you to say that the Act contemplates a range of corrupt practices. Those are the ones defined in Section 90 and then expanded upon in the subsequent sections, and illegal practices, which are those that we find in 99 to 101. But only those in 102 do you have an exemption where a third party is responsible for that. That's what the Act says.
I understand the submission to be that Section 102.3 is restrictive in terms of presenting illegal practices that would provide for the exemption of the voiding of an election.
Yes.
That there are illegal practices referred to elsewhere,
Correct.
which are not part of the exemption in 102.3.
That's correct, my lord. And those illegal practices are the ones that will find full flourishing in a Section 116 petition, which must say what corrupt or illegal practices or irregularity or any other cause whatsoever that party wishes to rely upon for the purposes of getting the relief which 121 empowers you to give.
Yes, but the issue then becomes where you decide to proceed by under the ground of illegality or that is not provided for under 102.
Yes. And it happily can fit under any
or
other cause.
Under any other cause. Are you saying you are not enjoined to indicate in the petition what the ground that you are seeking the nullification of the election is and particularize that?
No, I've never suggested
Because that is what they are saying.
and they're completely incorrect.
Yes, that is what they're saying, that looking at your petition, reading your petition, you have not stated in any way or form that you are proceeding under any other ground that you could have, that you had access to under 116, except the corrupt and illegal practice grounds.
I suppose, my lady, to preface what I'm going to, before I illustrate to you, the problem for the BDP respondents is that they believe that everything lives in boxes. And they try to force things into boxes. And that's where they get lost. Because if you read our petition, you will see that it articulates irregularity, it articulates illegal practices, and it articulates corrupt practices. If we just start reading it, you will see. They tell you in paragraph 13 that Mr. Baikalafi is the whistleblower, and he has certain of these things. He tells you in paragraph 14 that a war room strategy was determined by the governing party at the highest level to involve persons who have access to state resources, to use these to ensure that the BDP remained in power. And we don't have to put that into a box of corrupt practice or illegality. It's certainly a factor that would invalidate an election.
But for purposes of a party appreciating what your case is all about.
Look at the facts.
No. If you have a claim for 1 million pula, but your claim, that is the generic amount that you are claiming in the normal course of things when
Yes,
you
in a
are
commercial
moving
matter.
an action in a
Yes.
commercial matter. The total amount you want from X is 1 million pula, but this amount is computed of different claims.
Yes.
Claim A, B, C may each be founded on a different course of action, but the total amount you claim is 1 million. Can you just say, well, you owe me this, without particularizing each claim separately so that the other party understands what your course of action in respect of each claim is and how the total of 1 million is derived?
The first thing I'd say to your ladyship is that we're not dealing with causes of action in the way that we deal with with a contract or a delict. We're dealing with a sui generis process, the fairness of a trial, beg upon the fairness of an election. And if my clients had simply said, I am a candidate and I want you to exercise your powers under 121I, that is, to declare that nobody was elected, then I could understand what a submission that was made to me, that wouldn't be enough. But here you've got an extremely particularized description of the facts. All of these facts cumulatively present a flood, a great tidal pressure behind a trier of facts. If we had to accept these facts as true, is there a court in this country that wouldn't say that there's been an undue election of this petitioner, of this candidate? It would be hard for me to believe that that could be the case. The facts are set out in paragraph 15. In June 2018, Mr. Masisi, Mr. Balopi, Dr. Sarema, Mr. Dada, and Mr. Baikalafi had a meeting that was convened at Tsoletsa House. There were the Director General of Intelligence and Security Services there. There was a discussion, and what was clear to all parties present, says this person, is that the message conveyed by Dr. Masisi was win by any means, in inverted commas. Then...
That is a conclusion.
No, that's testimony, with respect, my lady. That's a witness saying, I was at that meeting. I heard what was said. I understood what was said to mean, go out
That's
and
what
win
he
by any means.
understood. He cannot impute that to other people that are not here, can he?
Well, he certainly
making
can get into a
conclusion
witness
of
box.
his understanding of the message, but not that what he interprets or interpreted that to mean is what he's stating in the paper.
Yeah, and that will be examined in cross-examination in the trial, my lady. With great respect. He's telling you what he understood, and that's how language and communication works, is that we interact with people. We may not understand what was subjectively in the communicator's mind, but we understand, and we might be right or wrong. But we go on. On paragraph 16, on the 23rd of October, Brigadier Makhosi was to cause the registration of front companies to be used for money laundering purposes, to pay bribes to different persons. If you want to fault this petition, it's an over provision of particularity. It's pleading the factor probantia rather than just the factor probanda, if there was such a thing as a course of action in this particular matter. They talk about the plan to pay voter registration officials. They talk about how the registration cards were to be duplicated and how a program to allow persons who should not vote, should only vote once, to vote twice. How to bring it about. This is not an irregularity, if this is not an illegality, if this is not corruption, if this is not all of the reasons upon which a party can bring a cause to this court, asking you to please guard what the IEC should have guarded but didn't, I don't know of a stronger case.
So it is one of those. It may fall anyway. That's what your submission is.
No, it can fall in every one of them, and
That's
it does fall in every
and
one
your
of them.
clients need not have specified that under irregularity, this is what we are complaining about. Under corrupt practices, this is what we are complaining about.
Correct.
Under illegal practices, this is what we are complaining about. So that the other person understands what your case is all about.
Yes, we would be as strong as possible in our submission to your ladyship, that the Electoral Act does not require that of a petitioner. A petitioner must explain what he says went wrong in this election, why it's an undue election, and can rely upon all facts. He doesn't have to put a label upon it. His label may even be wrong. He may believe something is a corrupt practice when we look, oh no, it's in fact an illegal practice. These are categorizations which are irrelevant to the substance of what we're dealing with. Law is not about putting things into boxes and putting labels upon them. Law is about bringing justice to the facts. And these facts could not have been more clearly, forthrightly, and in depth pleaded with great respect. And I've only got to paragraph 19. This goes on to paragraph 61. I don't want to belabor this point. If your ladyship is against me and says that I was required, my clients were required.
No, I want to understand
the
what
submission.
you are saying. The fact that I'm
No, and I
pleasing you,
appreciate
I'm
the
not
engagement.
making any conclusions or anything. I want to understand, and I'm applying what you are saying to what they have submitted on, so that I understand what your case is all about.
I beg your
Yes,
pardon,
you
my
cannot
lady.
take offense when I do so.
I beg your pardon, my lady. What I'm saying to your ladyship is that I would urge upon, my clients would urge upon the court that an over-technical and formalistic approach to the way in which the complaint is structured does not belong in this process. It has no place in this process. But we got into this debate, my lady, because I was addressing you on their false construct of the world, which says, and I read it to you again in their heads of argument, that for Section 105 to apply, the election candidate, the corrupt or illegal practice was committed by the candidate. That's what they say 105 means. And with great respect, it doesn't mean that at all. Section 105 doesn't say that the candidate is supposed to have been guilty of those. It doesn't even say that the candidate must have knowledge of it. It says only that where it's happened and a polling agent or a election agent, if I've got them right, has knowledge, then their knowledge is coming home to the candidate, even if that candidate knew nothing about it. If their agents knew about it, it's coming home. Section 105 deals with a tiny subset of the potential conduct that may be examined in an election petition. And it tells the court that if this happens, it's a red card, a straight red card. It's no yellow first. It's a straight red card. You get off this field. That's what it says. It doesn't deal at all with whether or not the election candidate was a party to the shenanigans or knew about them, because that is not a requirement for the purposes of determining whether or not a person has been duly or unduly elected. It doesn't have to come home to the candidate that's being challenged at all. You'll read this act in vain for any provision that says that the candidate must have knowledge before we're going to set it aside. And with great respect, if we just step back a minute and we pause and we look at history that is littered with petty dictators who get their henchmen to commit the most heinous actions and then say, well, I didn't know anything about it, I didn't do anything about it, I'm still fine. That is the subversion of democracy. It's the subversion of the temple that the founding mothers and fathers built when they produced a constitution, and they said that the sacred space in this constitution is the election, and the high calling of the court is to guard this process. So I think I've addressed with respect why we say that the BDP respondents' contentions in relation to the allegation that my clients haven't pleaded a case under 105A is bad. There are two reasons. Firstly, 105A doesn't apply the way they say it applies. It doesn't deal with knowledge or participation of the candidate. So they've got it completely wrong. But secondly, your power to bring my clients the relief which they ask for does not pass through the gate of Section 105. It passes through the gate of Section 116. And the test that you apply is not to see whether or not a corrupt practice as envisaged in 105A has occurred. It is whether or not there was an undue election. And that is why Section 140 tells the court that we're not going to be, you are not enjoined to be a school teacher marking right, wrong, you will have to have a look whether if he should have got 3 points more, it had an outcome, effect on the outcome. That's what Section 140 says. Can I then turn to, and with respect, that's the heart of these objections. That's really the crux of what they've tried to advance. That's the only really interesting point with respect in the points in limine. And if I just move back from those, I'll go to the other points now, but if I just move back from that proposition, we must pause and ask ourselves, is that an issue that should be determined before the trial? Or is that a thing that must wait for the evidence? Because what if the court had to be hearing evidence and knowing that it has power to subpoena witnesses and cause them to give evidence, it finds that there is a legitimate avenue of inquiry that should be pursued that has not been raised by the petitioners? Must the court close its mind? Must it pretend that it's not the guardian of this sacred space? Of course not. The court will call that witness and say, come and tell me what it is that you know, because I must determine whether this election must stand or not. My Lord, I interrupted you. I think you wanted to ask a question. And
well, I was going to take you to Section 140, and you mentioned it.
Yes.
And it makes reference to Part 6 and 7.
Yes.
By reason of any mistake or non-compliance with provisions of Part 6 or Part 7.
Correct.
I understood the respondents, the second respondents, to indicate that they bring their case under Part 10, unless I'm mistaken.
So may I make sure that I've understood what your question is?
Under Part 10.
They say
They will say Part 10
is mandatory. Part 10 compels for peremptory or mandatory compliance with the provisions of the Act.
yes.
And that their arguments are anchored, therefore, under Part 10.
Yes, so that's the jurisdictional fact category of points that I'm going to come to in a moment. But so that I can just express myself, I hope try and express myself clearly here. When a party complains about particularly an irregularity, I'd imagine that those irregularities would most often be found under Parts 5 and Part 6 and Part 7. They deal with the elections and polling, where irregularities can happen. Those is where we'll find many of the irregularities, but we'll also find things that we might also call illegal, but so as not to confuse them with an illegal practice. Under Chapter 9, we should just call them irregularities. And those irregularities, if they are sufficiently weighty, can set aside the election, can deliver an answer, a verdict that this was an undue election on their own. But, says 140, if we're just dealing with the kinds of irregularities that would arise under Parts 6 and Part 7, and please, I don't want to be bound and says that irregularities only belong there. I haven't done a full audit of the Act to see whether or not something is essentially an irregularity. But even if they are, if it would have had no outcome, then we're not going to interfere. We're going to look at substance over form. I cannot see an Act which has a clear indication, a mandate to the court, that they've got to deal with truth, not appearance here. Reality, not fiction. That's how Section 140 works with respect. And 140 is part of Part 10. It's part of how a petition for an undue election must be evaluated and considered. May I proceed?
Proceed.
Okay. Can I then deal with let me just find my note. What in effect are the exceptions that were raised by Mzitu Mileng? If I can just remind you, her complaints were that Mr. Polokholo, who is the person in Kanye South, refers to Tlokweng. That was the one complaint that she raised. Then her second complaint was that Mr. Molebatsi, that there's a hearsay, there's a body of hearsay in this petition, which has not been confirmed. And then when she was asked the question, what is the effect of that, she with respect struggled to answer, and I'm going to hopefully answer that question to you. And then the third thing that she dealt with was in relation to Molebatsi and Peko. She said, these persons do not link the events which they describe to their particular constituency. You'll recall that she referred to paragraph 45 of that affidavit, saying that all of Gaborone didn't mean Gaborone Central. You'll recall that point. Now, if we look at these complaints and the submissions that are made here, at best, they amount to complaints that the petition has a contradiction, that it might cause prejudice, and we know what that is in our law. That gives rise to a vagueness or an embarrassment for a litigant. Now, vagueness and embarrassment is cured in one of two ways. If you believe that it goes to the root of the cause of action, if we're dealing with a cause of action, then you can accept. You say that if we accept everything that is true, no cause of action is founded. Or you can request particularity to address what would otherwise be a lack of particularity. Now, both of these procedures are adequately dealt with by the rules of court. And it's true that I think on this point, my learned friends and myself agree. Namely, that Section 123 contemplated that we would get rules that would help the sui generis process. We haven't got those rules, and we're trying to use the High Court rules to give us a way to handle this matter. And Kono's case has said that should be the case. But I doubt very much, with great respect, that the persons who were writing the High Court rules at the time they wrote them were thinking about the Election Act when they wrote them. And so we're trying to fit something which doesn't really belong well into this particular set of rules. But we must do the best that we can, because we're not Parliament. And we can't make those rules, and we can jump up and down and shout and dance about it as much as we like. They may not do anything about promulgating those rules. But the court must still do its job, and so we must fall back to default, which is the High Court rules. I'll pause just for a minute to say this, that once this court gets engaged in this process and leaves behind these preliminary fights and these skirmishes that we're dealing with, my submission is that what Section 121 through to 139 do is allow you, under a sui generis process, to establish your own procedure and to be as robust as might be necessary to be able to deliver something in 90 days. Because although I've practiced law for over 20 years, I have never, ever achieved the start of a case and its conclusion from pleadings to judgment within 90 days. It's even hard to do that in a private arbitration where the parties have said that they will try and resolve the matter in 3 or 4 weeks. It still never happens, just because of the way that things go. Now, you're under a burden to try and produce this result within 90 days.
Don't you think that is why maybe issues of exception and Order 33 that deals with the removal of cause of complaint will not work in election petitions because of the strictures in time.
Correct.
And that where they are points that could be raised, then raising them as points of law is the best thing under the circumstances.
Yes.
To deal with those as quickly as possible and move forward.
Yes.
If the matters go to trial, and deal with the substance of the petition.
Yes.
Because if, as much as the court may try to infuse the High Court rules into this process, there are some of those rules that the court will be restrained to do so.
Yes.
And in my view, exceptions and those provisions of Order 33 are some of those, because you have to give the other person notice, they have to respond to that. If they don't, you have to still move an application, and time is passing. Already a month is gone.
My lady, with great respect, I must say I can't agree with you more with one rider, and I'll get to the rider in a moment. That must be correct with respect. If there are points that can be raised that are dispositive of the matter, then those should be raised right up front. But these are points that are what I've labelled, and I criticise my opponents for labelling, but which are properly labelled jurisdictional facts. Because if my client doesn't bring his petition within 30 days, on a proper counting of those days, he doesn't get into the court. It doesn't matter how interested we are in the case that he has to say. Those are true defeaters. Those matters are the ones that the court should determine and flush out. They are chaff, they do not belong with the wheat. But there are other kinds of things which do not fall into that category. And complaining that there's a contradiction between Tlokweng and between Kanya South is one such example. And when we say in our written submissions, tongue-in-cheek, I must say, that our learned friends want to insist upon the High Court rules and all the rigors of the High Court rules, but they don't comply with it when it doesn't suit them, like under Order 33, then they're inconsistent, is the kindest word, the way that we can describe it. It doesn't help to raise these kinds of points. When you look at them, they really, everyone can see that we're dealing with, in the context of a robust process that where a petition must be delivered within 30 days, about a matter that is of ginormous importance and must be resolved in 90 days. Of course, there are going to be imperfections in pleadings. That is inevitable. I don't know a practitioner who has run a case from start to finish on his pleadings without ever amending or wishing he'd said something differently. It just doesn't happen like that. We are not infallible. And so when you read at page 108, the petition of Mr. Polokgolo, and you see that he says and establishes his jurisdiction without any doubt in paragraph 2 that he was a candidate for the Kanya South constituency. And you see at page 106 in his power of attorney that he's challenging the second respondent's election in the Kanya South constituency. And you turn later in the petition to page 117 and you read paragraph 55.3, which asks this court to declare that the Kanya South constituency seat is vacant. Then you know that the reference to Tlokweng at paragraph 8 and paragraph 8 at page 109 and to paragraph 56 at page 117 is obviously an error. It's one that is perfectly explainable. I am instructed by a legal team that have literally had to break themselves to put together 16 petitions in 30 days. And the cutting and pasting inevitably gives rise to these kinds of problems. These are things that will need to be addressed by the witnesses that give the evidence. But we know that the undue election is a challenge that's happening in the Kanya South, East, West, I'm now lost, Kanya South constituency. And we know the facts upon which it's going to be relied. Those facts will either make it or they will not. Those facts which have been alleged must be able to be amended. It cannot be the case, which is the way that the BDP respondents see the world, that when the petition is delivered, a photograph is taken. And for the rest of eternity, the world must look like that photograph. Even though we discover that no, that photograph isn't correct. The law doesn't work like that, and certainly justice can't. This petition must be capable of amendment. even though it has been signed and verified by the petitioner. To hold differently would be to impose such a demand of formalism on a procedure that is intended to be swift, fast, and which is inevitably going to give rise to errors and mistakes that simply does not belong, with great respect. So that really deals with Mr. Polokgolo. It also deals with the complaints about Mr. Molobatsi and Mr. Peko. I don't know if they're Mr. or Mrs. Forgive me, it's Ms. The requirement that says Ms. Itumeleng that when Order 3, I think it's Order 3, which requires that the petition be verified by the petitioner with a verifying affidavit, when that rule stipulates that it could be either the petitioner or his agent, that what it's signaling is that the legal practitioner who's drafting the documents must determine whether there is some of the content of the petition that is within the knowledge of the petitioner and some which is outside, and therefore when it's outside there must be a confirmatory affidavit or a duplicate verifying affidavit, or perhaps even just because it's the verifying affidavit, simply also doesn't fit in the sui generis process that we're dealing with here. It's wrong, because we're not in motion proceedings. We're not about, this petition does not purport to, and it's not expected to, and it should not be required to establish in the way that an affidavit establishes the evidence that will be proved in a trial. It is a pleading. It is a document which sets out the facts upon which this party relies for why it says this person was unduly elected. I emphasize again and again that there is not one reference in the whole of the Electoral Act to an application. It's always a trial of the complaint, of the election petition.
I'm not sure I understand the submission that a lawyer is expected to deduce from an affidavit who should confirm what, verify what. Lawyers do that all the time. When a lawyer drafts an affidavit, he knows whether the deponent is speaking about facts known to himself or referencing matters that he got to hear from somebody else. And as a matter of course, those people have to confirm or verify. So I don't understand why it should be different in petitions, more so considering the strict nature that has to apply to petitions. And are you saying a petitioner who says in his petition and verifies what he has said in his petition says, I was told by Mr. Baikalafi that A, B, C, D, E, and E happened. At the very least, of all the people that that petition could refer to, that to me seems to be a crucial person that runs across all these petitions. And in fact, most of them, Baikalafi has verified, except on a few. So how do you even explain that?
Yes, okay.
Yes.
So let me start with where we must start, which is section 116 of the Act, 118.1, sorry, which says that a petition is only required to be signed. The statute requires only that the petition be signed. It's an imposition from a different set of rules prepared for a different purpose through the case of Cornwall, or perhaps it was earlier than that, that said that, well, we must treat this petition like any other petition, and it must also be verified. Now the question is the strained interpretation that my learned friend advances, namely that the petition must be signed by the petitioner or by his agent, does it mean that I must not only sign by the petitioner, which is common cause, every single one of these petitions has been signed by the petitioner, but I must also sign by every witness that's going to confirm any piece of evidence that is hearsay in the mouth of the petitioner? That's what her argument means. That's what she says. And our submission to you is no. Go back to section 118, and it requires only a signature. Section 33, Rule 3.2 says, confirm it.
Rule 12.
Beg pardon?
Rule 12, sub-rule, Order 12, rather. Order 12, sub-rule
I'm losing track.
3.1, I think.
But whatever that rule is,
Yes.
says that it must be confirmed. And it's common cause that every single one of the petitions has been verified by the petitioner. The question is whether there must be additional affidavits. And we say that that's not the purpose of the petition, because it's not there to establish every aspect of evidence. Otherwise, we wouldn't have a trial.
But what is the person who's verifying? What is he verifying? Can someone verify? And what is the import of verification or even confirmation? Can you verify something that you don't have first knowledge of?
Yes.
Where you say somebody else said A, B, C, D, E, can you really verify the appropriateness or otherwise of those facts that you attribute to another party, a third party?
Yes, we would say you have to and you must, especially when it comes to these kinds of petitions. Our law recognizes two broad distinctions between proceedings. The one is trial proceedings, where viva voce evidence is led, an oath is administered, and a witness leads evidence and is cross-examined. And those instances where there is no dispute of fact anticipated, where you go by way of motion proceedings, and where you set out in an affidavit those facts, where every fact that is relevant for your cause of action must be confirmed by affidavit, and must either be within a person's personal knowledge, or must be confirmed by somebody who has personal knowledge, or must be admitted under one of your hearsay exceptions, which I don't know what they are, but I'm sure that they prevail as much here as they do in the jurisdiction that I practice in. That's how that evidence gets in.
I'm still not clear on your answer.
I'm not finished yet.
Yes, in the cases where the verification has not been done, the two matters.
Where the what hasn't been done?
The two matters where there is no verification by, at least by Galafi, because that is what the point
Yes, but Galafi is not the petitioner.
I'm still to finish what I'm trying to say.
Yes.
The rest of the petitions by Galafi has verified, though he's not the petitioner.
Yes.
Why was he verifying,
Well,
if not to verify what he has told the petitioner, because that is not first-hand to the petitioner. And where he failed to do so, can the petitioner verify facts that are not in his personal knowledge?
Well, my lady, let me first point out the rather humorous aspect of this. Mr. Balakaifi, I can't even say it, Mr. B. Mr. B has confirmed the allegations in 4 or 5 or 6 of these petitions. Those exact same allegations, because these documents follow the same form, are utilized in other petitions, and there he hasn't signed. But we know he's confirmed them because we've seen the other confirmations of the same allegations. Now we want to, in these proceedings, say, where is Mr. B, to come and confirm those things again, which he confirmed once, twice, 3 times, 4 times there, but didn't do in 5 and 6.
Why not if the petitions are separate?
Yeah.
My lord and my lady, I don't know why he didn't file a confirmatory affidavit. I say to you, it's not required, and it would be burlesque
It is
to
not
require it.
required, but the Court of Appeal has said it is. And should we depart from that decision of Kono? Because Kono recognizes that the Electoral Act does not state that the petitioner should verify.
Yes.
Yes, it doesn't say that. It says the petition should be signed.
Yes.
But the Court of Appeal decision of Kono then said there should be verification either by the petitioner or on his behalf.
No, the Kono only says it must be by the petitioner.
It doesn't say that.
It doesn't.
It refers to Rule Order 12, which
Correct.
says by the petitioner or
Correct. And it then holds that it
another
must.
person on his behalf.
Correct.
So I can imagine a situation where, on behalf of Mr. Boko, I'm not involved in the issue, and I come and I sign a verifying affidavit on his behalf. Is that what is envisioned by Order 12, Rule 3.1?
Well, let me give you an
Can I
example
do
of
that?
what is.
Can I verify what the petitioner has not verified, because that rule says by him or someone on his behalf?
Yes.
Is
So let me
that
give you
what I can do?
Yes, let me give you an example of how that will work perfectly. In order for me to appear in this court, I need to be admitted. That admission is done by way of petition. Assume that I am not able to verify that petition, for whatever reason. But the attorney that gives me instructions here in Gaborone verifies it on my behalf.
Yes, because he has knowledge of what he's doing. Can
How-
I, as someone
how-
who doesn't know anything, verify?
How does he have knowledge about
He's the
whether or
one who
not
prepared the
there is
document.
any disciplinary proceeding pending against me, whether or not I have an LLB, whether or not I have been admitted to practice in a
That is
Commonwealth
what
jurisdiction?
he presents to the court. So there's an assumption that he has verified those facts from wherever he needs to verify them from.
Well, with
or he
respect, my
got
lady,
them from you.
with-
But my question was, if I know nothing of what the petitioner states, unlike by Galafi or someone else, by Galafi may verify because he has said something, told the petitioner something, may verify facts that he knows something about that he told the petitioner about. But when Rule Order 12, Rule 3.1 says by the petitioner or someone on his behalf, does it envision any person, or that speaks to what ordinarily happens when a deponent to an affidavit depones to facts that are otherwise hearsay, but then becomes not hearsay because the person who told him then has to confirm or verify those
So,
facts?
so again, I repeat, a petition is not an affidavit. So we're not dealing with confirmatory affidavits of facts that are made in an affidavit. A petition is a special kind of document. It's a pleading which sets out certain facts, which only one person needs to sign: the petitioner himself or somebody on behalf of that petitioner. It's not required to verify the facts in the petition.
Counsel, you are wrong. The petition has to be signed only by the petitioner.
That-
The issue of signing where someone
what I
else
said.
comes in is the verification, not the petition. The petition is in terms of the Act, which does not then stipulate verification. Verification is where the Court of Appeal has borrowed from the High Court rules and referred to a specific rule in the High Court where then that rule says, for verification purposes, it has to be done by either the petitioner or someone on his behalf.
I said it incorrectly. A petition only needs to be verified by one person: the petitioner or somebody on behalf of the petitioner. It's not an exercise in closing the gaps on hearsay evidence. That is our submission, and you'll hold it against me or not, but that is the submission. It's the correct submission with respect. But just to take the example that you gave me and show with respect why I persist so strongly in the submission. If Mr. Boko or any one of the other petitioners, let's assume Mr. Boko is the first one to sign his petition. There he gets Mr. B's, an additional verifying affidavit from Mr. B. And the second petitioner reads the same affidavit, the same allegations from Mr. B, and then confirms those allegations that he has seen has been confirmed by Mr. B, then surely he has enough knowledge, just as my attorney, who will admit me if I'm not present, because he's got the information from somewhere, to be able to verify on my behalf if that was necessary. It's, again, it's not the confusion with respect which the BDF respondents raise is a confusion between a verifying affidavit and a confirmatory affidavit. Now I'll move on, otherwise we'll be here all day. So the last category of submissions, and these were addressed by Mr. Manawe, really are matters that are jurisdictional facts. Now we know jurisdictional facts, or the concept of a jurisdictional fact, from public law, where we ask ourselves when a person exercises a power, whether the preconditions to the exercise of that power are present. We call those jurisdictional facts. Before you can exercise the power, the jurisdictional fact must be present. And they live well and comfortably within administrative law, that administrative law branch of public law. But the analysis is very useful also to a court that exercises a power under a statute, which is what you are asked to do when you conduct a trial under Section 121 of the Electoral Act. in order for you to be able to come to the assistance of my clients, they must bring themselves within the requirements that the Act requires. And when you look at each jurisdictional fact, you must ask yourself when the jurisdictional fact must be present, and you must ask yourself whether, in that well-known, well-trodden area of law, whether substantial compliance with the jurisdictional fact is sufficient, or whether there must be absolute or complete compliance with a particular jurisdictional fact. Now, the three that have been raised, or is it four, each need to be looked at differently. Let me deal with the easiest one, because it's it's either an in or an out answer here. The requirement that the petition be brought within 30 days is one that brooks of no departure. You are either within the 30 days or you're outside of those 30 days. The court doesn't have a jurisdiction because it cannot enter upon the matter to exercise such a jurisdiction because it hasn't come through the front door.
You agree with the respondents, second respondents?
They didn't cast it in this way. I'm putting to you the way that with respect the proper analysis. So then let's look at. So there are two cases that have been raised where the days are an issue. It's Malabatsi and Mochekga. Now, what the papers in both of those applications say is that on the 24th of October, the returning officer declared the BDP candidate the winner, the respondent in each of those cases. And so they say, when you begin to count, you get to the 23rd of November. And they say that you start counting from the day after, which is what the statute requires, the announcement, which is from the 25th, and you get to the 23rd. That's how they analyze it. If they're correct, I must concede that those two applications must fail. But we say they're not correct. And this is our argument. We start with the Interpretation Act in sections 26 and 27. Every enactment shall be deemed remedial and for the public good and shall receive such fair and liberal construction as will best attain its object according to its true intent and spirit. And in the construction of an enactment, an interpretation which would render the enactment ineffective should be disregarded in favour of an interpretation which will enable it to have effect. We might say that this is a general provisions in favour of the remedy, in favour of the rights of the particular individual. Now we say that when you use section 40 of the Interpretation Act, which governs the measuring of time, there is an interpretation of the way you count the time that will give life to sections 26 and 27. It will allow the remedy. It will be in favour of the liberal interpretation. So what we find in section 40...
40 or 40?
40. It deals with interpretation of terms, periods. The relevant ones first are 43, wherein an enactment a period of time is expressed to be reckoned from or after a particular day, that day shall not be included in the period. That's what our statute says. It's 30 days after the date of announcement. We know we start counting from the 25th. Then it says, 4, wherein an enactment a period of time is expressed to end on or be reckoned to a particular day, that day shall be included in the period. So it's not, if it's within 30 days, it must happen on that 30th day from, where I come from, we say we exclude the first and we include the last, is effectively what that's saying. But then it says in 5, where the time limit be an enactment for the doing of anything expires on a Sunday or public holiday, the time so limited shall extend to, and the thing may be done on the first following day that is not a Sunday or public holiday. What that tells us is quite correctly, as my learned friend said, that you don't take public holidays and weekends into account at all in counting those 30 days, except when the 30th day falls on a public holiday or a Sunday. And we work on Saturday in Botswana, I see. If it falls on a Saturday, you deliver your documents, your 30 days. Now, what happened in this matter is that the 30th day and the way they count fell on Saturday, the 23rd of November. But our papers were filed on Monday in these two matters, the 25th of November. So how do we get out of this? We say it's to be found in sub 8. It says, where in an enactment anything is required to be done on a particular day, then if that day happens to fall on a Sunday or public holiday, the thing shall be considered as duly done if it is done on the first following day that is not a Sunday or a public holiday. Now that sounds very much like section 5, subsection 5, but the difference is that section 8 deals with something being done, and section 5 simply deals with the question of counting. And what we say happened in this matter was that the 23rd was a public holiday, the 24th was a public holiday, and the 25th was a public holiday, which means that you don't do that thing which is to start counting on the 25th. You do it and do it lawfully, says section 48, on the next day, which is the 26th. And what that then does is move our 30 days to the Sunday, and what we are able to do then is do it lawfully on the next day. So we say that those two petitions that were filed on the 25th were so lawfully filed because although the Act says you start on the next day, that's when you start counting, that's when you are to do something, to start counting under 48. 48 says that if it's a public holiday or a Sunday, you can do it on the next day, which is the 26th. And then you add your 30 days, it takes us to Sunday, the 24th, and then says 40 sub 5, you can do it on the next day. And that's what happened with these two elections.
What is it that is being required to be done? Is it not the filing of the petition?
No, there is a filing of a petition, but that would be exactly the same as 45 then. We don't see if...
No, that's what I'm asking. Insofar as 8 is concerned.
Yes.
Where in any
Required
enactment anything
doing
is required
something.
to be done. So when you extrapolate this to the scenario or the complaint that is raised, and they say the filing was done late,
Yes.
and in terms of the Act, the filing has to be done within 30 days.
Yes.
So the thing to be done, what is it? Is it
Yes.
not the filing?
That, of course, is the question. Of course, filing is something that can be done, but we also say that this commencement of the starting of the counting is also something to be done. Because you can't count unless you start counting something. You can't do anything unless you start there.
The commencement of the counting is something that is to be done.
Yes, counting is something that should be done. And you've got to count 30 days.
Not the filing.
No, the filing as well. Otherwise, we can't get to the 25th. We say that it's both. You've got to start counting on a day, and if it is a public holiday, you can't start counting on the next day.
Councillor, you're not clutching at straws now.
No, I'm urging upon you an interpretation that is faithful to sections 26 and 27 of the Interpretation Act.
You said is the filing as well as what?
Yes, so
The counting.
The counting.
Counting. Those are both things that must be done,
What is being counted? For what purpose? To what end?
Yes.
so that you can know where you start and where you end. That's why you count.
The only way to lodge a petition is to file it.
That's true, but the only way to know when you can file it is to start counting.
Are we not extending the interpretation too far?
So that is the submission. That is the submission that we make. And we
Okay.
submit that it's a perfectly legal submission. But there's one other submission that we make, and that's this. The court should be loath to necessarily non-suit these two applicants because they have spoken from their position of knowledge such as it is. What is required is that the returning officer deliver the date. Deliver the outcome. But what happens in ordinary life, I think across the world, certainly I know, is that elections are not announced by the returning officer. They're announced by the radio. Often days before the returning officer announces the result of the election. And so if you look at what has been pleaded by these two persons, you'll see that they don't say that the returning officer delivered that result on the 24th. They say that that's when they learned of the outcome, on the 24th. So it may be that the returning officer, in fact, only announced it on the Saturday after the public holidays, which would be consistent with the way that civil servants would work in this matter. And so we need to actually establish what the date of the returning officer was on this particular matter.
Was that not for the is that not for the petitioner to
establish?
Should
But
have
he could-
established that.
But he hasn't, and I would be open to criticism if you say I didn't file a further affidavit, a supplementary petition saying that this is what it, but we haven't had the time.
He has not. In fact, what he has done is to give us a specific date
Yes, when
when
he
the results were announced. So he cannot turn around and say, no, by the way, I only learned after Sunday or Monday at
Yes.
some other later date. When in the petition, he gives the court a specific date.
Yes, when he learned, but it's not when he learned that's relevant. What is relevant is when the returning officer makes the pronouncement.
Yeah.
And that
that-
is what he says.
No, what he says is that this is the date that he learns.
No. Which petitions are we referring to?
Mr. Mochekwa is at page 292. Ms. Mochekwa. And at page 298, you'll find paragraph 3.1, which says, in relation to Christian Grief, that the second respondent was on 24 October 2019 declared the winner of the elections. It doesn't say that that declaration was by the returning officer.
And he doesn't say that's when he learned of the election. Does it say that?
I would say that the assumption that that's when he learns about it is a safer one than the assumption that that was when the returning
Why
officer
is that
announced
a
it.
safer one?
Because he's speaking from his personal knowledge.
But
So
that,
all I'm saying is
will
at this
that
stage-
not be relevant in terms of
For him to know,
Prescriptions
then it should
Act.
have been said by the electoral officer. It should have been announced by the electoral officer. You cannot talk of learning if the announcement has not yet been done. So if anything, then it would have been earlier. It cannot be later.
No, it certainly could have been later. What normally happens with elections, with respect, my lady, is that there's an election centre and everyone's counting, you're going crazy, and people stayed up all night, and finally when the candidate says, I can't make it, then they shake the hands of their person, and then
What happens
then the
in
media gets
Botswana
it.
is that they announce.
Yes, it happens.
Immediately at the end of the counting, the electoral officer announces.
Correct, right at the end.
Paragraph
That's when you have
11
the
is very
returning officer.
specific.
Pardon?
Paragraph 11 of Mr. Motsewa's petition says, based on the result of the said count on the 24th, the first respondent, through the agency of the returning officer,
I'm sorry,
declared the
I hadn't read
results.
that. I can't make that submission then. Yes, I can't make that submission then. So you have to either decide whether what is admittedly a creative interpretation of your counting powers under Section 40 of the Interpretation Act, whether that can survive, or whether, and if you can't, then those two petitions can't make it. They can't cross the line. So that's a jurisdictional fact. That's one that's appropriately taken in limine, and it's a matter of law, one that can be decided without any further evidence then, whether Section 40 can be used in the way that we seek to use it for the purposes of this petition. Can I then address the others, please? The second complaint is that there is no notice of presentation that was given. And if you look, for example, in contrast at page 1, the petition of Mr. Boko against page 142, the petition of Mr. Ramatwana, you will see that there is a covering document for each of the series of documents that commence on page 1 and 142 respectively, that describes the title of the High Court, identifies the petitioner and the two respondents, and then between tramlines in the case of Mr. Boko says notice of presentation of election petition, and in the case of Mr. Ramotwana says filing notice. The contention in this case by the BDP respondents is that because between the tram lines on page 142 and in the other instances too, it doesn't say notice of presentation of election petition section 118 Electoral Act, that this document somehow does not give notice to the person receiving it that a election petition has been presented to the court. Now, with respect, that's wrong. In fact, it's wrong in law. It's just wrong in common sense. What is the document? What is the way in which the presentation of an election petition is signified? Well, it has to be the stamp of the court. It doesn't matter what you call the document that covers it. You could call it cover note. You could call it anything you want. But what communicates to the recipient of this document that this thing has been presented to court is the court stamp, which you find on each page. At page 142, the High Court of Botswana Civil Registry has signed on the 22nd of November 2019 that the documents were received. That is how presentation of the petition has occurred. And that petition is a composite document. It consists of the documents that are listed on the filing notice, the power of attorney, the petition, the verifying affidavits of those persons in this case. No complaints there, I'm sure. The list of proposed sureties, the draft recognizance, and the draft surety bond. If we look at what section 118 of the Act requires, it's again not the contorted interpretation which my learned friends try to put on it, but a perfectly common sense one. It simply says, notice in writing of the presentation of a petition and of the names and addresses of the proposed sureties shall within 10 days after the presentation of the petition be served by the petitioner. So when you take a document that shows that it's been presented, you have given notice in writing of that presentation. And it doesn't matter what you call it. This rose would be as sweet smelling were it called by any other name. So with respect, that point in limine is a poor one, but it is indicative of the lengths to which the BDP respondents will go to prevent a full ventilation of matters that should properly be ventilated.
So I understand your submission to be that once the petition is registered with the court,
yes,
and it is served on the other party,
yes,
that is a presentation.
No. Presentation happens when it comes to a court. And what you've got to give is notice that you've presented it to the court. You present the petition in terms of section 116.
Within 10 days after presentation.
Correct. Okay. Correct. So you present it to the court acknowledges it's been presented by stamping it, and within 10 days thereafter, you give them notice. And the best way to give it notice would be to deliver the documents. There can't be a better way of giving notice than that. The last of the the third of the complaints was with section 118's requirement that the addresses of the surety be provided in the petition. This, with respect, requires a little bit more construction of what the statute is about. And with respect, this is not a matter that was examined in any depth in Cornell's case, and it certainly books of a proper investigation in light of Tito's case. What Tito's case tells us is that whether or not shall means must, or is peremptory, and may is merely permissive or empowering, is a question that depends upon a proper construction of the statute and the intention behind the legislature. And with the question about secured surety then demands that we look at this, because again, we're not involved in a tick box exercise. we ask ourselves, why does the legislature require security to be given, and how is it to happen? The obvious answer to that is that they don't want frivolous and unmeritorious cases leaving a person who prima facie has been validly elected not being able to recover some costs for the irritation, if it is truly an irritation, of having to defend this election petition. That's what the security is for. But what we see is that under section 119, that the respondent may, by notice in writing served upon the petition in the manner referred to in section 118, within 21 days after the date of service and notice referred to in the said section, object to such recognizance on the ground that the sureties or any one of them are insufficient, or that a surety is dead, or that he cannot be found. If he cannot be found, it's because he doesn't have an address, or that a person named in the recognizance has not signed the same, or that the recognizance is invalid or defective. So what the Act says is that this requirement of putting up a surety is in fact a matter that is not cut and dried on the day that the presentation of the document happens. Because if you can't find the person, you can object to it. And then, if the objection is upheld, the way in which the petitioner continues is that he must put up cash himself or herself. So that the objectives behind the legislative enactment are completely addressed by the way in which the provision for suretyship is given. And the time when this has to actually be determined, when this jurisdictional fact must be present, is in fact not at the time which on the surface is suggested, namely at the moment when the petition is delivered or lodged with the court, but it's at the time when the court must start its action, or at least after the expiry of the period where there might be an objection under section 119, because it's always open to a petitioner to be able to produce the money, the cash, the hard cash, himself or herself. And that wouldn't disqualify him or her from proceeding with the petition. So when we look at this particular jurisdictional fact, we see that when we analyze it in the context of the statute and what the intention of the legislature was, we can see that this would not have been a disqualifier. This would not have been one that would result in being non-suited. If the petitioner can address the substance of the suretyship, then he can surely address the form in which it is being presented. But the second answer to this complaint really is the answer that's suggested by Section 23 of the Interpretation Act, which says, as we've read, that where a form is prescribed or specified by an enactment, deviation from the form not materially affecting the substance or calculated to mislead shall not invalidate the form used. My learned friend on this score said, form means template, I think is what he says. Unless the Act itself prescribes a template, as the Electoral Act does from pages, depending on my Electoral Act, starts putting out these forms from page 63 of this printed version, Form A through to Form U. He says that the the Interpretation Act has in mind those forms. With great respect, that attributes a lack of imagination to the drafters of the Interpretation Act, because in ordinary experience, forms can be drawn, they can be templates, but they can be described in words. Words is what we deal with all the time. And when Section 118 requires that there be that there be compliance with what is therein described for the purpose of the suretyship, we say that it's no more than a matter of a form, including the address of the surety, and that under the circumstances, Section 23 has full traction in this area, and that it will not invalidate the petition merely because no address has been given. Lords and my lady, on that rather abrupt note, I think I've covered all of the ground. I just want to take instruction from my instructing attorney, just make sure they haven't left anything out. So just in summary then, if I may, there are really three categories of points in limine that have been raised. The first one is a powers issue. And we say that you should be guided by, firstly, your constitutional power in section 67, I beg your pardon, 69, read with section 95, and a proper interpretation of section 116 through to 121 of the Act. And that our case is not about section 105A. Our case has nothing to do with 105A. It doesn't find application. We don't make one allegation that an agent of a candidate knew and therefore a red card must be given. We rely upon the expansive, broad power which you have to determine whether or not a person has been duly or unduly elected. Then as far as the complaints that have been raised in the form of exceptions, we say that if we're going to be overly fastidious about rules, then they should comply with Rule 33, Order 33. But we say it rather tongue-in-cheek. We say that this is a sui generis process. It must be dealt with in a robust manner where little points without substance do not derail the train. And then, as far as the jurisdictional facts are concerned, we say that unless you agree with us on we concede that unless you agree with us on our interpretation of sections 45 and 8, there are two petitions that may be in trouble on their 30 days. But as far as the others are concerned, the one is the tram lines issue, which we say is a non-issue, and the other one is the other one has to do with the security and the addresses for security. We say there you must interpret what the intention behind that jurisdictional fact is and when it's to be measured. We have asked in our written submissions for that these points be dismissed with costs, including the certified costs of counsel. That is a I suppose error on my part because I don't frequent this jurisdiction enough. We would need the costs of the counsel that have worked in this can I say the local council, Botswana council here. So, and there have been also 3 council that have been working in the matter. So both parties are saying whoever wins gets 3 council, if it'll please. Thank you.
Mr. Bayford?
Yes, my lord.
Earlier on, you indicated that the Babusi ward, you will tackle it.
Yes, my lord. There is the matter of Opri Tumelo Ramatsebanyana, who is the petitioner. I must say that the objections that have been raised are identical to the objections that have been raised in respect of the majority of the petitions. In this particular petition, the issue of lucus standi, as my learned friends have indicated, has since been abandoned, leaving the objectors with the requirements under Section 118 of the Act, as well as the parameters within which Section 105, subsection A of the Electoral Act have to be considered. My learned friend has just, in quite some detail, traversed these matters, and I think in order to avoid prolixity and tautology, it might serve the interest of time to associate myself with the able submissions he has made and have them adopted mutatis mutandis in respect of this particular petition. Unless if the court would wish to address me specifically, that is what I would like to state.
Thank you, Mr. Bayford.
Thank you, my lord.
Should we adjourn? Can I have the first respondent to reply? Yes. Break. 10 minutes before the first respondent reply.
Yes.
Keep first
Second
respondent.
response.
Before second.
We can reply.
Let's take a 10-minute break before the second respondent responds to the questions raised. Court rests.
Are you ready?
Iya, Let's see. Eish. Hata ege. Hata ege kae ko PK. Okay. Again. Panela. I'll be fine. Ra? Kita nak korek biasa slowan. How to make camera right? To be fine. Yes. Emma. Re tsala jalo re tswale re go amogela motsana wetsho gone ha kgotlatshekelo gone mo Gaborone High Court re go tlhalosetse jalo gore ba atlhodi ba setswa go goroga gone ka go teng ka kwa mme re go tlhalosetse jalo gore ha re ya go ikhutsa kgantele go tere go khutsa metsotsonyana ile 10 nyana hela e ne ile gone gore go sentse go ngangiswana ka yone kganya gore ba party ya kganetso ile bone ba UDC gone gore e rile ha ba isa di petition tsa bone gone mo kgotlakgolo ya ditsheko ba ne ba sa sala jalo tsamaiso tshedimosetso e leng teng e leng gore ba ne ba e bua jalo e le bone ba BDP mme kgotsa motshwanetso re go tlhalosetse jalo gone gore tota e ntse e tsweletse e tshwerwe ke bone batlhodi ba bararo bao e le ene matlhodi Michael Buru, Michael Messi Garekwe le ene matlhodi Godfrey Radijeng mme motshwanetso a re tshwaragela gone gore ne re tswelele re go bona gore go diragala jang mo teng ga golo ya rona e le yone ya ntlokgolo ya tsheko.
To the case of Mithilesh Kumar versus Venkataraman and others, the Indian case. At page 8, the Indian case which is reported in 1989, Law Reports of the Commonwealth, at page 1.
The page number, Mr.
Page, at page, the report is at page 1 of the 1989 Law Reports of the Commonwealth. And I'm going to quote at page 7, paragraph F. And it reads thus: it is not open to a petitioner in an election petition to plead in terms of synonyms. In these petitions, pleadings have to be precise, specific, and unambiguous, so as to put the respondent on notice. The rule of pleadings that facts constituting the cause of action must be specifically pleaded is as fundamental as it is elementary.
You will avail a copy.
We will definitely avail the copy.
Thanks, yes.
Now, the reason why these pleadings have to be specific is so that the respondent is put on notice and knows precisely what case the respondent has to meet. Now, at page 8, the case further goes on to say that they, meaning the petitioners, cannot be allowed to keep their options open until the trial and adduce such evidence of consent as seems convenient and comes handy. That is the importance of precision in pleadings, particularly in election petitions. My lords and lady, the respondent, in realizing that they had boxed themselves into a corner by relying on corrupt and illegal practices, now want to move around the Electoral Act to find where next they can base their complaint on. And our position is quite simple, my lords and ladies. There is nothing in their pleadings, nothing in their pleadings which ought to move this petition from the stage where it is now to a trial, because there is no specificity in their pleadings. See, a trial in an election petition is not there simply for the asking. I think my learned friend is under the impression that once they file a petition, it must inevitably result in a trial. There are hurdles such as these ones that they need to go over. And it is our contention that they have failed to go over this hurdle of a specificity in their pleading. Yeah. Now, my lords, that in brief would be my response to the points as raised by the petitioner. I will leave my colleagues to respond to other points.
My lords and lady, I'll respond briefly in relation to the issues raised by my learned friend for the petitioner. The gravamen of the submission seemed to be to trivialize the requirement for addresses in terms of Section 118 of the Electoral Act. A narrative is sought to be peddled that, well, these are matters of form, these are not serious issues, we can do without them. My quick response is this. Anybody who buys that has surely not had regard to Section 119, subsection 1 of the Electoral Act. Well, Section 118 tells us that the notice must have addresses of sureties. Section 119, subsection 1 tells us what should we do with the notice we get in terms of Section 118. It reads, the respondent may, by notice in writing, served upon the petitioner in the manner referred to in Section 118 within 21 days after the date of service on him of the notice referred to in the said section, object to such recognizance on the ground that the sureties or any of them are insufficient, or that a surety is dead, or that he cannot be found. Now, it is common cause that when you look at page 319 of the bundle, that is the petition of Ketlalifile Motserwa. If you look at 319, we have names of sureties but no addresses. If you look at page 361 of the bundle, the petition of Marie Bright Molebati, we just have 2 names of sureties but no addresses. The question arises, how is the respondent going to exercise his rights and interest as provided for in Section 119 if he doesn't have addresses? How is he going to find out that he's there, the surety is there, when he doesn't have the address? If he doesn't have the address, how is the respondent going to locate him? Because Section 119, subsection 1, presupposes that as the respondent, I must satisfy myself as to who this person who stands as surety is. How can I satisfy myself that he's dead or where he cannot be found when I have not been provided with addresses? Or whether he has property. Or whether he's just a vagabundus or a man of straw. For that reason, we submit that the issue of provision of addresses of sureties is not a trivial matter, as the petitioners want us to believe. It is a serious issue. This explains why petitions have been struck out before by this court where there has not been full compliance with Section 118. And we submit there is absolutely no reason, be it in fact or in law, why this petition cannot fall. We rest our case. Thank you.
Mate Millen, you have nothing to...
No response from
Okay.
me, my lords, my lady.
We will render our decision next week, Tuesday, on the 24th of December at 10 a.m. Court rise.
Hey, mister. Okay. I got to say, I underline. Can I work?
Oh, I'm sure you won't render a fee note for this fan and sub now that you've gone through that. No, it must be terrible having to listen and not being able to participate. And you know what? And you have to listen to it all again tomorrow.
re garela jalo motsana wa itshomo kgotla ya ditsheko e le moatlhodi Michael Luburu a garela jalo a bua gona gore ba tla tsa tshwetso jalo ka kgwedi yone ya Sedimonthole ka di 24 ka nako ya 10 mo mosong mme go tsa re gakole jalo gore ganye e ne ye emetswe ba bueledi ba bo bararo e ne le bone bomang e ne le wa IEC e le advocate Utsilera Mmidi ba BDP e ne le basimane bogopa le ne busa manewe le bonolo itumeleng mme ba party ya kganetso ba UDC ene ele Jonathan Verton le advocate Philip Langa Bondlani le ne advocate Dick Bayford mme motsonatso e wetse hana jalo e le gone go nganyisana hela gone gore e le bana ba party e busang ya Botswana Democratic Party ba tlhalosa gone jalo gore party yone ya kganetso ba ileng gore ba isone petition gone mo kgotlatshekelo ha ba sala jalo ditsamaiso dingwe morago gona le melaonyana e nneng ba ntse ba enang kola ba ibua ba tlhalosa le gone gore dingwe tsa tsone di petition tse leng gore di ne di tsile jalo gape le ga le khotla di isitswe jalo malatsi a masome a mararo a sena go heta ba bua gone jalo gore ke ngwa dintlha tse leng gore ba di lemogile gone mo di petitioneng tse leng gore di isitswe pele ke bone ba party ya Umbrella for Democratic Change mme motsana wetso a re wetse hela jalo re emela jalo di 24 tsa kgwedi yone ya December ka 10 am e be re tla rutla gone gore ba tlhodi ba ilebile ka tselentseng jang.
Thanks for bringing this forward to you. Thanks, man.